Hey guys, welcome in. Matrix Media here again. Just checking out some documents from the Karen Reed civil trial. Her wrongful death claim, the O'Keefe's wrongful death claim against Karen Reed and the bars, C.F. McCarthy's, Waterfall, and I believe there was one other place. We'll get into it and read the documents, but first I want to go over a couple definitions of some things so that there's a better understanding. So let's start out over here. So a civil complaint is the initial legal document filed in a civil lawsuit as opposed to a criminal case. All right. Sorry, I lost it. Okay, so a civil complaint is the initial legal document filed in a civil lawsuit as opposed to a criminal case. That formally starts the case in court. It is submitted by the plaintiff, the person or entity suing, against the defendant, the person or entity being sued. So Karen Reed and the bars in this situation are the defendant. Key elements of a civil complaint. Caption includes the court name, parties involved, plaintiff versus defendant, case number assigned later, and title. 2, jurisdiction and venue. Explains why the court has authority over the case and why it's the proper location. 3, parties, identifies the plaintiffs and defendants. 4, statement of facts, a numbered factual narrative of what happened, not opinions or legal arguments, just facts. 5, causes of action, legal claims. What are the legal claims that you're making? Not just I want to sue you. Specific legal grounds for the lawsuit. Example given, breach of contract, negligence, or fraud. 6, prayer for relief. What the plaintiff wants. Example given, money damages, injunction, or specific performance. And then 7, signature, signed by the plaintiff or their attorney, certifying the claims are made in good faith. So that's the process and elements of a civil complaint. So, and then I also looked up and asked Grok, what is a tort claim? So we hear that a lot, at least, in life. I'm sure people hear it or come across it, and I've always wondered what it was up until recently. So a tort claim is a civil, non-criminal legal claim in which one party, the plaintiff, seeks money damages. So it's about money. A tort claim is money damages or other relief. Or other relief from another party, the defendant, for harm caused by wrongful conduct. So a tort claim is a civil claim and made by the plaintiff. It's for money damages or other relief from another party for wrongful conduct. The word tort comes from the Latin tortum, which is twisted or wrong. And tort law covers private wrongs, not breaches of contract, but violations of legal duties owed to others. Continue on. Core elements of any tort claim must be proven. 1, duty. The defendant owed the plaintiff a legal duty, example given, to drive safely or to keep premises safe. 2, breach. The defendant failed to meet that duty. And 3, causation. The breach directly caused the harm. And then finally 4, damages. The plaintiff suffered actual harm, physical, financial, emotional. Common types of tort claims. Intentional torts. So you have different types of torts. Intentional torts, which is assault, battery, false imprisonment, defamation, intentional infliction of emotional distress. Negligence, which is most common, according to AI. Car accidents, slip and fall, and medical malpractice. Strict liability, defective products, abnormally dangerous activities, and then nuisance, loud noise or pollution interfering with property use. Economic torts, fraud, interference with business relations. How to start a claim. Okay, we don't need to do that. Then I also asked Grok AI, what is wrongful death in civil law? Wrongful death in civil law is a tort claim specifically a type of negligence or intentional tort claim that allows certain surviving family members or representatives to sue when a person's death was caused by the wrongful act, neglect, or default of another. So basically, Karen Reed, they claim, caused his death, so therefore she's liable. It is not a criminal charge. It is a civil lawsuit for money damages only. Who can file a wrongful death claim? Excuse me. Depends on state law, but typically, eligible plaintiffs are immediate family, life partners, financial dependents, or personal representatives. Note, only those listed in the state's wrongful death statute can sue. For example, siblings usually cannot unless they were dependents. Okay, but it also says it varies from state to state. So check your local laws. What must be proven? Same as negligence and death. Duty, breach, causation, and damages. Let's see here. I think I asked it one more as well. I told it to add negligent. Okay, no, and then it gave me some weird stuff. So what is negligent or reckless? Oh no, it was and or. What is negligent and or reckless? What did I say? Infliction of emotional distress. Intentional infliction of emotional distress. So, let's see. Reckless intentional infliction of emotional distress. So, well, Graxton's thing. It refers to two related but distinct tort claims in civil law that allow you to sue for severe emotional harm caused by another's wrongful conduct. These are standalone causes of action you can add to a civil complaint alongside negligence, wrongful death, or negligent infliction of emotional distress. So that's kind of the, I don't want to say background, but the legal definition, the few definitions that we're going to kind of want to understand to read this and help understand a little better. So let's get into it and check it out. Again, don't forget to like, subscribe, and my friends over on Twitch, don't forget to follow. We're going to bring court and court documents over to Twitch. Other than just gaming, we're going to get court and LawTube over there. We're going to call it Law Twitch. So anyway, let's get into it. Commonwealth of Massachusetts. This is in Plymouth County. So this is Plymouth Superior Court. It's not Norfolk County DA's office, thankfully. Well, it wouldn't be the DA's office anyway, but you get my point. So Paul O'Keefe as personal representative of the estate of John O'Keefe, Paul O'Keefe individually and John O'Keefe II, Margaret O'Keefe and Margaret O'Keefe as grandparent / guardian of Kaylee Furbush. Plaintiffs. That's all of them. And then it's against CNC Hospitality LLC, CF McCarthy's GNS Hospitality LLC, and CF McCarthy's Waterfall Bar and Grill Limited, Waterfall Bar and Grill, and Karen Reed, which are the defendants. So, bear with me here. Okay, so parties and jurisdiction. The plaintiff, Paul O'Keefe, Paul is the surviving brother of the late John O'Keefe, John J. O'Keefe III, JJ, John or decedent, and is the duly appointed personal representative of the estate of John Joseph O'Keefe III, who died on or about January 29th, 2022. At all relevant times material hereto, the decedent resided in Canton, Norfolk County, Massachusetts. Excuse me. I'm so sorry. At all relevant times material hereto, the plaintiff Paul resided in West Bridgewater, Plymouth County, Massachusetts. The plaintiff, John O'Keefe II, is the surviving father of JJ and Kristen. So John O'Keefe III is Officer John O'Keefe. God rest his soul. So that is JJ, but also John O'Keefe III. John O'Keefe II, I believe, would be Officer John O'Keefe. That would be his father, which is married to Peggy, John O'Keefe's mother. Officer John O'Keefe's mother. All right. So they reside at One Meadows, which is John's old house. The plaintiff, Margaret O'Keefe, is the surviving mother of JJ, John O'Keefe, and Kristen. At all relevant times material hereto, the plaintiff, Margaret, resided at One Meadows Ave. The plaintiff, Kaylee Furbush, okay, we're not going to talk about her. At relevant times, the defendant, CNC Hospitality, LLC, C.F. McCarthy's, is an independently owned restaurant with a usual place of business at 614 Washington Street, Canton, Norfolk County, Massachusetts. C.F. McCarthy's had a resident agent, Stephen B. Carey. C.F. McCarthy's presently appears to be operated by GNS Hospitality, LLC, whose date of organization was 4/24 of 2023. GNS Hospitality and DBA, C.F. McCarthy's, has the same location of business and same resident agent as CNC Hospitality, LLC. Any averments referencing or counts against C.F. McCarthy's should be assumed to incorporate either or both entities listed here. So basically, they're all one and the same. GNS Hospitality, C.F. McCarthy's, and CNC Hospitality. They all have the same location of business and same resident agent. So basically, they're all one and the same. So they're saying that they should all be assumed to incorporate either or both entities listed here. 6. The defendant, Waterfall Bar and Grill, DBA, Waterfall Bar and Grill, is a domestic corporation with a usual place of business at 643 Washington Street, Canton. Waterfall has a registered agent, Gerard Meehan, located in Canton as well. The defendant, Karen Reed, is an individual residing at Mansfield, Bristol County, Massachusetts. Number 8, plaintiff repeats, realleges, and incorporates by reference as set forth hereto in their entirety all prior paragraphs of the complaint. The decedent, JJ, was the middle of 3 children in a tight-knit family. JJ was a third-generation Boston police officer. So let's just, I don't know if this will let me highlight or not. Okay, so JJ was a third-generation Boston police officer. After the tragic death of JJ's sister, Kristen, and brother-in-law, Steve, JJ took custody/guardianship of his niece, Kaylee, and nephew, Patrick, who were 6 and 3, respectively. This family has been through a lot. It's awful. I wouldn't wish it on my worst enemy. I really wouldn't. Over the next 8 years, until his tragic passing, JJ raised and supported his niece and nephew. So not only did these poor children lose their mother, then their father, then they also lose the guardian who was raising them since their parents had passed. I mean, my heart just breaks for them. It absolutely breaks for them. I could not imagine. I feel for every single one of them. I really do. After the tragic death, he took guardianship. After the tragic death of JJ, Margaret, Peggy, his mother, took guardianship custody of her grandchildren, Kaylee and Patrick. At all relevant times on or before January 29th, 2022, JJ and defendant Reed were in a dating relationship. Okay. So let's put that in there. In the months, weeks, and days leading up to January 29th, JJ and defendant Reed's relationship was deteriorating. During such time, defendant Reed picked fights, experienced jealousy, and had delusions of unfaithfulness. My whole thing on that is that is entire speculation. 100% speculation on the person's part who told or wrote or whatever came up with that. That's insane to me to say. But apparently in civil law, it's much, much different. Rules and stuff are much more lax. Evidence is much more lax. The bar is much lower as far as the threshold of proving your case and, things of this such. It's a much lower bar because it's civil and it's not criminal, if that makes sense. On or about January 28th of 2022, defendant Reed knew that her relationship with JJ had run its course. Again, how do they know that? You know what I mean? First of all, how do they know that it had run its course? And second of all, how do they know that that was Karen Reed's thought process? Where do they come up with this shit? I mean, okay, so on January 28th of 2022, at or about 8:51 p.m., plaintiff arrived at CF McCarthy's. Okay. CF McCarthy's was licensed to distribute, sell, or serve alcohol. On January 28th of 2022, at about 8:58 p.m., CF McCarthy's served Reed an alcoholic beverage. Reed consumed said drink. On January 28th of 2022, CF McCarthy's, through its agents, servants, or employees, served alcoholic beverages to defendant Reed at or about 9:13 p.m., 9:20 p.m., 9:33 p.m., 9:57 p.m., 10:22 p.m., and 10:29 p.m. Reed consumed such drinks. So they're saying she had 1, 2, 3, 4, 5, 6, 7 drinks. CF McCarthy's, through its agents, servants, or employees, served defendant Reed 7 alcoholic drinks between 8:58 p.m. and 10:29 p.m. on January 28th. During all relevant times at or before 10:29 p.m. on January 28th, defendant Reed showed signs of intoxication while at CF McCarthy's. On January 28th, 2022, at or about 10:40 p.m., JJ and defendant Reed left CF McCarthy's. Okay, so 10:40, JJ and defendant Reed left. On January 28th, 2022, at or about 10:40 p.m., defendant Reed was allowed to carry her alcoholic drink out of CF McCarthy's. On January 28th, 2022, at or about 10:54 p.m., JJ and defendant Reed entered Waterfall together. Okay, so that's important too. This is a timeline. At all relevant times, Waterfall was licensed to distribute, sell, or serve alcohol. Defendant Reed walked into Waterfall carrying a drink from CF McCarthy's. At all relevant times on January 29th, 2022, while at Waterfall, defendant Reed showed signs of intoxication. Between 10:54 p.m. and 11:54 p.m. on January 28th, 2022, defendant Waterfall served Reed 1 shot and 1 mixed alcoholic drink. Reed consumed such drinks. Okay, so there again, she had 7, 8, 9 drinks. Right? That's 9. 7 plus 2. So on January 29, 2022, at approximately 12:10 a.m., defendant Reed left Waterfall. Okay, so she left at 12:10. On January 29th, at approximately 12:11, JJ left Waterfall. Okay, yeah, because I remember she went out before him. At all relevant times on January 29th, 2022, between 12:11 and 12:36 a.m., defendant Reed was under the influence of alcohol and unable to drive a motor vehicle safely. Yeah, so between 12:11 and 12:36. So basically like 25 minutes. 15 minutes. Whatever. At all relevant times on January 29th, defendant Reed drove JJ to the residence of 34 Fairview Road in Canton. The infamous 34 Fairview Road, Canton, Massachusetts. Defendant JJ had been in an argument the night of January 28th, 2022 into the early morning of January 29th, 2022. After JJ got out of defendant Reed's vehicle in front of 34 Fairview Road on January 29th, 2022, Reed drove her SUV and hit JJ. At all relevant times on January 29th, 2022, defendant Reed drove her SUV in a state of intoxication. As a result of Reed's SUV hitting JJ on January 29th, JJ was knocked down onto the ground in front of 34 Fairview Road, suffered serious injury, and died. Okay, again, they don't know this because, and also, well, here's the thing. They can put whatever they want in the complaint. Let's just make that very clear. They literally can put whatever they want in the claim. Their claim can be whatever it wants to be, right? They can say whatever they want, right? And so here's my thing is, but she was found not guilty of unaliving John O'Keefe. So it's hard for me to swallow that you know, as a result, Reed's SUV hitting JJ knocked him down and onto the ground in front of 34 Fairview, suffered a serious injury and died. But that's not true because the jury says otherwise. That means that they agree with the science, with what the experts said, the biomechanical engineer. I mean, this is crazy. After hitting JJ with her SUV, defendant Reed fled the scene and returned to JJ's residence at 1 Meadows Ave. At all relevant times, defendant Reed knew that it was snowing, knew there was an impending blizzard, and knew or should have known that leaving JJ outside in the blizzard would likely result in serious injury or death. Sorry, I got to turn my fan off. At all relevant times when defendant Reed drove her SUV and hit JJ, defendant Reed A, failed to use any care to avoid creating an unreasonable risk of harm to the public and JJ. Okay, so this is, I'm assuming, maybe part of the prongs for proving the intentional infliction or the negligent infliction of emotional distress or reckless. B, voluntarily took an obvious risk under the circumstances, knew or should have known that death or serious injury was reasonably predictable. C, persisted in a clearly negligent course of conduct over a noticeable period of time. D, was impatient with reasonable precautions. And E, was deliberately inattentive to the predictable hazards of her actions. And or F, was deliberatively inattentive when there was a risk of great and immediate danger. At all relevant times when defendant Reed drove her SUV and hit JJ, defendant Reed was reckless when A, she intended the reckless conduct that resulted in JJ's injury/death. B, her conduct made it highly likely that someone, namely JJ, would suffer serious injury or die. C, she knew or had reason to know of the risk of grave injury or death to JJ, or said risk would have been obvious to a reasonable person. And D, she intentionally or unreasonably disregarded that risk. E, JJ's injuries or death resulted from defendant Reed's decision to engage in the conduct referenced above in 16-17 or 16 and 17, 26 and 37 A and D, or A through D. On January 29th, 2022, at approximately 4:30 a.m., defendant Reed knew that she hit JJ with her SUV. Again, how do they know this? You know what I mean? This is all, I mean, that's purely speculation. They have no evidence to support that. Nevertheless, she woke up to JJ's 14-year-old niece, Kaylee, Nevertheless, she woke up JJ's 14-year-old niece. Karen Reed woke up Kaylee, the niece, and talked about JJ's death. Talked about hitting JJ with her SUV and otherwise involved Kaylee in her frantic calls about JJ's death. I think this was proven to be not true. I'm gonna have to look into that because I remember something about that. At all relevant times on or about January 29th of 2022, defendant Reed knew that Kaylee was a vulnerable minor who already lost her parents tragically and depended on her custodial uncle, JJ, who became her surrogate parent. At about 5:07 a.m. on January 29th, 2022, defendant Reed left One Meadows Ave. Between 5:18 a.m. Let me highlight this real quick. Between 5:18 a.m. and 5:35 a.m., defendant Reed knew JJ was seriously injured, buried in the snow, and laying on the ground in front of 34 Fairview Road, Canton, where defendant Reed left JJ to die hours earlier. On January 29th of 2022, defendant Reed admitted repeatedly that she hit JJ. Again, no recordings of this, no audio of this on any police body cam, no nothing, nowhere. No dash cam, no nothing. But everybody seems to, not everybody, a couple people, 2 people I think it was, seem to claim she said that. And of course that comes in threes as well. I hit him. So, again, we proved that was not true. She was found not guilty. So she did not say that. Obviously the jury didn't believe it. They weren't convinced because that's pretty damning evidence to confess at the scene and the cops don't take you in. Then when you say, I hit him, if you said it then, why didn't they take you right in? They should have took you right in. Detained you and questioned you, maybe not arrested you, but questioned you 1,000%. If I was an officer, I would have, if I would have heard that or been told that by the paramedic, Katie McLaughlin. Katie McLaughlin was a liar, allegedly. On that stand, she told some stories, in my opinion. Okay. And one of those stories was, I hit him. That was 1,000% fabricated, in my opinion. Okay. And she no longer works there, allegedly, either, at the fire department. Canton Fire Department. Okay. At relevant times on January 29th, JJ suffered trauma injuries before becoming hypothermic. So he hit his head and probably knocked him out unconscious immediately. It rendered him incapacitated. That's what the doctor testified on Karen Reed's defense, that he was immediately incapacitated. At about 7:50 a.m. on January 29th, 2022, JJ was pronounced dead at the hospital. At relevant times after 7:50 a.m. on January 29th, defendant Reed went to the grieving house of JJ, feigned comfort to JJ's family, and used the opportunity to, amongst other things, remove the offending weapon, her vehicle, and or destroy relevant evidence. Give me a break. Remove the offending weapon. Oh, I went and got my car, you mean? I mean, give me a break, people. This dude, I mean, we're going to have to go over the hearing because the guy, the attorney for the O'Keefes, when he talked about this in the oral arguments a couple weeks ago, it was literally like you could tell he had practiced it in front of a mirror or in front of a couple buddies or something, because it was just way too animated. There was no jury. It was just the judge listening to them. So you don't need all that Alan Jackson hyperbole. You know what I mean? All that extra stuff, because nobody's listening. There's no dramatic sense to it. So there's no sense in it. But he still did it. And I guess maybe the cameras were there, so maybe that's why he did it. Probably why he did it. On January 29th, 2022, defendant Reed's blood was drawn, reading 93 milligrams per deciliter. I'm not sure. I don't know. I'm not going to guess. 93 mg/dl. A serum conversion and retrograde extrapolation was done of the results of defendant Reed's blood, with the results showing her BAC would have been between 0.13 and 0.29, around the time she drove the SUV and hit JJ. Reed's BAC of 1.3 to 0.13 to 0.29 all exceeds the legal limit to drive a motor vehicle in Massachusetts. At relevant times on or about January 29, 2022, defendant Reed drove her SUV while under the influence of alcohol and hit JJ with her SUV. As a direct and or proximate cause of Reed's drunk driving, JJ sustained serious injuries of body and mind, conscious pain and suffering, fear of impending death, lost earnings, medical, funeral and burial expenses, and died. Wait a minute. So, JJ sustained serious injuries of body and mind, conscious pain and suffering, fear of impending death, and lost earnings. Wait. That's crazy. So they're saying that he died, but while he died, he had the fear of impending death, lost earnings, medical, for what he went to the hospital and the ambulance and all that coming, funeral and burial expenses, and he died. So basically, all of that was caused to John O'Keefe. But how, if he was literally incapacitated immediately? That just sounds weird. It just sounds weird to me to say that. How does he suffer all of that if he passed away? Unfortunately. Notwithstanding her Fifth Amendment right not to speak, defendant Reed chose to speak publicly. She knowingly and deliberately changed her story and fabricated a conspiracy. Wow, that's quite bold. That's quite bold, in my opinion. She changed her story and fabricated a conspiracy, knowing the same to be false. She publicly communicated this false narrative, thereby frustrating justice for JJ. Such false narrative caused the plaintiffs aggravated emotional distress. The plaintiffs listed above bring this complaint seeking full and complete justice for JJ. Count 1. The estate of John Joseph O'Keefe III versus C.F. McCarthy's wrongful death. MGL C 229 subsection 2. The estate repeats, realleges, and incorporates by reference, as set forth hereto in their entirety, prior paragraphs of the complaint. Defendant C.F. McCarthy negligently served alcohol to an intoxicated person, namely defendant Reed. Defendant knew or should have known that defendant Reed was intoxicated at relevant times of service on January 28th of 2022. Defendant C.F. McCarthy violated Massachusetts dram shop laws, company safety policies, and was otherwise negligent for numerous reasons, including, but not limited to: A, its decision not to hire competent employees; B, its decision not to provide adequate personnel to work at C.F. McCarthy's at relevant times; C, its decision not to provide adequate safety training to its employees, staff, bartenders, and servers; its decision to violate safety training; E, its choice to retain unfit employees; F, its choice not to supervise adequately its employees, staff, bartenders, and servers. The defendant, C.F. McCarthy's, acted not only with indifference to its legal duty not to serve intoxicated patrons, but also with utter forgetfulness of said duty. The defendant, C.F. McCarthy's, acted with gross negligence. The defendant, C.F. McCarthy's, acted with willful, wanton, and reckless disregard for the safety of others when it served an intoxicated defendant Reed. The defendant, C.F. McCarthy's, deliberately ignored the appreciable risk and or voluntarily incurred the obvious risk of serving defendant Reed, when she was already intoxicated, C.F. McCarthy's persisted in serving Reed alcohol well after it knew that defendant Reed was visibly intoxicated. Defendant C.F. McCarthy's continued to serve defendant Reed alcohol at relevant times when Reed was already intoxicated. As a direct and proximate result of defendant C.F. McCarthy's negligence, gross negligence, and/or willful wanton disregard for safety, J.J. sustained serious injuries of body and mind, conscious pain and suffering, fear of impending death, lost earnings, medical, funeral, and burial expenses, and died. As a direct and proximate result of defendant C.F. McCarthy's negligence, gross negligence, and/or same thing, JJ's next of kin suffered as well. JJ's next of kin are entitled to JJ's lost value resulting from his wrongful death. Okay, that makes more sense as to why they would say that he had lost earnings and that it cost money to bury and and all that stuff. Okay, that makes sense now because the children would have had a better life, and yeah, I see. Basically, if he would have been able to make this money and carry it out. Wherefore, the estate of John Joseph O'Keefe III demands judgment against defendant C.F. McCarthy's on count 1, plus cost, compensatory and punitive damages, lost value to next of kin, and any other relief this court deems appropriate. Count 2, the estate of John O'Keefe versus Waterfall Bar and Grill. That's going to be the same exact thing. Well, no, it's not. The estate repeats, realleges, and incorporates by reference as set forth here. Hold on, my wife just texted me. Sorry. Defendant Waterfall negligently served alcohol to an intoxicated person, namely defendant Reed. Defendant Waterfall knew or should have known that defendant Reed was intoxicated at relevant times of service on January 28, 2022. Defendant Waterfall violated Massachusetts dram shop laws, company safety policies, and was otherwise negligent for numerous reasons, including, but not limited to, A, its decisions not to hire competent employees, its decision not to provide adequate personnel to work at Waterfall at relevant times, its decision not to provide adequate safety training to its employees, decision to violate its safety training, its choice to retain unfit employees, choice not to supervise adequately its employees, staff, bartenders, and servers, etc. The defendant, Waterfall, acted not only with indifference to its legal duty not to serve intoxicated patrons, but also with utter forgetfulness of said duty. The defendant, Waterfall, acted with gross negligence. The defendant, Waterfall, acted with willful, wanton, and reckless disregard for the safety of others when it served an intoxicated defendant Reed. The defendant, Waterfall, deliberately ignored the appreciable risk and/or voluntarily incurred the obvious risk of serving defendant Reed when she was already intoxicated. Waterfall persisted in serving Reed alcohol well after it knew the defendant Reed was visibly intoxicated. Defendant Waterfall continued to serve defendant Reed alcohol at relevant times when Reed was already intoxicated. Okay, so basically literally the same exact thing. So wrongful death, again, that one was against Karen Reed, I believe. Yeah, this one's against Karen Reed. So that wrongful death is against Karen Reed as well. So negligent infliction of emotional distress. This is Margaret O'Keefe versus C.F. McCarthy's negligent infliction of emotional distress. The plaintiff repeats, realleges, and incorporates by reference as set forth hereto in their entirety. Prior paragraphs of the complaint. At all relevant times, Margaret O'Keefe was the mother of J.J., otherwise known as Peggy O'Keefe. Margaret O'Keefe learned of J.J.'s admission to the hospital immediately and came upon J.J.'s body at the hospital shortly thereafter. C.F. McCarthy's negligence caused the death of Margaret's son, J.J. Margaret suffered severe and profound emotional injuries, manifesting in physical symptoms as a result of observing J.J. at the hospital and witnessing the consequences of C.F. McCarthy's negligence. Okay. Margaret's emotional injuries, severe physical pain, anguish, emotional distress, and other harm were directly and or proximately caused by defendant C.F. McCarthy's negligence. A reasonable person in the same position as Margaret O'Keefe at the time of J.J.'s death would have suffered severe and profound emotional distress. Wherefore, plaintiff demands judgment against the defendant C.F. McCarthy on count 5, plus interest, costs, and any other relief or damages this court deems appropriate. So this is the same thing. John O'Keefe, this is against C.F. McCarthy's this time. This is John O'Keefe this time against C.F. McCarthy's. So Officer John O'Keefe's father, John O'Keefe. He is John O'Keefe II. Officer John O'Keefe is John O'Keefe III. So that's the same thing that I just read, just for John O'Keefe. This is also the same thing I just read, Paul O'Keefe versus C.F. McCarthy's. So it's just Paul O'Keefe's claim, negligent infliction of emotional distress. So this is Margaret versus Waterfall, negligent infliction of emotional distress. So the same exact thing. Literally, it's all worded the same exact way. I've already read through this. So same thing here. John O'Keefe versus Waterfall. This is John O'Keefe, Officer John O'Keefe's father. Negligent infliction of emotional distress. And then we've got Paul O'Keefe versus Waterfall, NIED. Margaret O'Keefe versus Karen Reed. This is negligent and or reckless infliction of emotional distress. This one I'm going to read because this one might be a little different. All right. The plaintiff repeats, realleges, and incorporates by reference as set forth hereto in their entirety the preceding paragraphs of the complaint. At all relevant times, Margaret O'Keefe was the mother of JJ. Margaret O'Keefe learned of JJ's admission to hospital immediately and came upon JJ's body at the hospital shortly thereafter. Defendant Reed's negligence caused the death. Sorry, guys, I have to take this real quick. All right, sorry about that, guys. All right. Were you looking at my full screen the entire time? Can you tell me in the chat? My wonderful follower on Twitch. Or have you been able to see the paperwork this entire time? If you could please type it in the chat, yes or no. All right, so defendant Reed outrageously created a false narrative. Margaret's emotional injuries, severe physical pain, anguish, emotional distress, and other harm were directly and or approximately caused by defendant Reed's negligence. A reasonable person in the same position as Margaret O'Keefe at the time of JJ's death would have suffered severe and profound emotional distress. Wherefore, Plaintiff demands judgment against the defendant, Karen Reed, on count X. I don't know what number that is. I don't know Roman numerals like that. Plus interest, cost, and any other relief or damages this court deems appropriate. And then this is the same thing. John O'Keefe versus Karen Reed. Paul O'Keefe versus Karen Reed. Negligent infliction of emotional distress. Kaylee Furbush. That one I'm going to stay away from because that's a minor child. So I don't want to really dig into that. And this is plaintiff's demand a trial by jury on all counts. Filed 8/23 of 2024. So, thanks for checking us out. I'm going to be doing a lot more of this. Obviously, I'm going to get better with time. So just bear with me. I've got a new microphone coming. Getting situated here, getting things figured out. So just bear with me, please. Don't forget to like, subscribe, and my wonderful Twitch people, please follow. Please follow. Please follow. Just like they say 3 times. I hit him, I hit him, I hit him. So go ahead and like and subscribe. Thanks, guys. I'll be back. Possibly we'll do something later this evening. I'll find something that we can cover, or maybe watch some court from this past week. There's some trials that started this past week as well, so we can catch up on those maybe or something. We'll find something to do. All right.